The latest in litigation against Illinois' gun and magazine ban includes challenges against Cook County's ban, Chicago's ban, Naperville's ban, and yesterday was when the governments defending the gun and magazine bans had to file their briefs in the 7th Circuit Court of Appeals. Good morning, Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Springfield's News and Talk. We've been tracking this since even before Governor J.B. Pritzker enacted the Protect Illinois Communities Act, also known as an assault weapons ban, also known as a ban on more than 170 firearms, semi-automatic firearms, guns like semi-automatic pistols, shotguns, rifles, including the popular AR-15 platform rifle. You also have bans on magazines over certain capacities. You can't have a magazine of more than 10 rounds for a rifle or more than 15 rounds for a handgun. Back in April, part of the law triggered that you can't be out in public with these things. So if you have a concealed carry pistol that carries more than 15 rounds in the magazine, that would be considered a violation, and you could face some criminal charges for that. But you also have the registration component of the Protect Illinois Communities Act, which kicks in January 1st. But all of this, you got lawsuits filed in the Southern District of Illinois Federal Court and the Northern District of Illinois Federal Court, and those have all been consolidated in the 7th Circuit Court of Appeals. After a mix of rulings in the Southern District, a judge issued an injunction against the state from enforcing the Protect Illinois Communities Act. That only lasted for 6 days before the state got the 7th Circuit Court of Appeals to reverse that injunction, and then they lumped the cases in with Northern District cases where judges sided with the state and local governments, saying that their gun bans are constitutional. So all of this, of course, an expedited briefing schedule after the U.S. Supreme Court was asked to intervene in the Naperville case. And when the U.S. Supreme Court requested Naperville to file a brief, you then had the state go to the 7th Circuit Court of Appeals, and they got that expedited hearing. So we'll actually have a hearing in this case in Chicago, June 29th. But briefs from the government were required to be filed yesterday. And we'll go to the PACER function websites where you can look up court cases, federal court cases and such. And you'll see that, you've got starting yesterday, attorneys filing as appearance for Cook County. You've got the city of Chicago submitting a brief filed by Chicago and also by the state, and other briefs filed there as well. Not all the briefs are completely visible to us at this point, but we can see at least the briefs here when it comes to the Herrera challenge and the filings from the city of Chicago. Now, one thing you can do is you can kind of just give an overview of the table of contents, and that, I think, really distills down what the arguments that the governments are making in these cases. So we'll just look at those bullet points in the table of contents, because this is a 90-page brief, which includes some, attachments and whatnot. But it says Herrera, who's a Chicago area emergency room doctor, he sued Chicago over their gun and magazine ban. They say Herrera is likely not to succeed on the merits. Assault weapons, they say, and high-capacity magazines are not in common use for self-defense. So it seems they're trying to just say it's only about self-defense when it comes to the Second Amendment, but it doesn't even say anything in the Second Amendment about self-defense. It says for the security of a free state. So I guess there could be some mincing of words as to what exactly is the security of a free state. But they go on to say assault weapons and high-capacity magazines are dangerous and unusual. They say AR-15s like M16s, and thus they may be banned under Heller, a decision, Heller versus D.C., landmark Second Amendment case. They also say assault weapons and high-capacity magazines are dangerous and unusual because of their extraordinary lethality. They also go on to say assault weapons and high-capacity magazines pose extraordinary risks to law enforcement, And continuing on, they say the city of Chicago's ordinance is consistent with the nation's historical tradition of firearm regulation. Because if you recall, the Bruin decision says you have to look at the history and tradition of the Second Amendment and the text of the Second Amendment. And a lot of courts across the country are having to reevaluate how they adjudicate Second Amendment challenges for governments enacting things like gun and magazine bans. So we continue on with the table of contents here from the Chicago brief that was filed yesterday in the Seventh Circuit. So they say the city's ordinance addresses dramatic technological changes and unprecedented societal concerns. And this is something else where you've got people who, ever since the Bruin decision was made, that say you can't balance public interest with constitutional rights, or I guess the other way, you can't balance constitutional rights with supposed public interest. For instance, you can't limit somebody's speech because somebody's feelings might get hurt. Well, you can't limit commonly owned firearms because of somebody having a fear that the proliferation of them will lead to unprecedented societal concerns, they say. So back to the bullet points here in their table of contents. They say the city's ordinance imposes a comparable burden on the rights of armed self-defense and is comparably justified. They go on to say Herrera will not suffer irreparable harm absent a preliminary injunction, and the balance of equities favors defendants and the public interest. So again, there you've got that balancing of rights versus public interest that the city of Chicago is making in their argument. Let's now go and check out some of the other arguments. Actually, you know what? That's the only one that's available at this point. If you notice, some of the other filings here on the PACER docket for the Seventh Circuit Court of Appeals, it says, note, access to this entry limited to counsel of record. Once the document is approved by the court, it'll be filed onto the court's docket as a separate entry. So we don't have that yet. But we do have at least Chicago's filing, which, again, lays out all of these bullet points in a 50-page filing, 90 pages when you consider some of the attachments. So let's go ahead and check out what they say in conclusion, all the way down on page 51. And here we are. Conclusion. For the foregoing reasons, this court should affirm the district court's judgment denying Herrera's request for a preliminary injunction. Obviously, this is going to be an ongoing situation where you have briefs that are expected to be filed now in 2 weeks from now from the plaintiffs' groups. You've got the Southern District cases, 4 of them that were consolidated in the Southern District, from the National Shooting Sports Foundation, the Illinois State Rifle Association, Federal Firearms Licensees of Illinois, and a case brought by Thomas Magg. And then you have all of those cases that were consolidated in the Southern Circuit Court. Judge Stephen McGlynn actually issued that preliminary injunction that was then reversed by the Seventh Circuit Court of Appeals. So all those cases in the Southern District moved up to the Seventh Circuit to be combined with the Naperville case, with the Herrera case out of Chicago and Cook County, and all of these being combined in the Seventh Circuit Court of Appeals with mixed rulings out of the various districts. And we'll have that hearing in Chicago for the Seventh Circuit Court of Appeals June 29th. So filings from the governments issued yesterday. 2 weeks from now, you've got filings from the plaintiffs, and then followed by reply briefs from government, I believe, and then you'll have June 29th, the hearing in the Seventh Circuit Court of Appeals. But again, just to go over where we're at in this, you've got the states, then the governments filing their briefs, and they seem to be wanting to balance interests over rights, saying that these semi-automatic weapons are dangerous and unusual, that they're like M16s, and that the high-capacity magazines and semi-automatic weapons are dangerous and unusual because of their extraordinary lethality. Assault weapons and high-capacity magazines pose extraordinary risk to law enforcement. They believe that the tradition of the long-standing tradition of regulating weapons that threaten public peace is consistent, and the city's ordinance addresses dramatic technological changes and unprecedented societal concerns. So that's where you're at right now with the state of Illinois' gun ban and Cook County's gun ban. We'll obviously be able to access the other filings whenever they're made available on the docket, and we'll talk more about that. But you've got other issues with gun rights across the country that are being taken up, including in Oregon, which we'll touch on that coming up here in just a moment here with Springfield's Morning News on 92.7 WMAY. Springfield's News and back at it and looking at the Chicago brief filed in the challenge against Illinois and Chicago's gun and magazine ban in the consolidated cases of the Seventh Circuit Court of Appeals. And just one thing I wanted to note, saw some people raise this issue on social media. And it's to this point about assault weapons and high-capacity magazines pose extraordinary risk to law enforcement, according to the brief filed by the city of Chicago. But people point out that most of the county sheriffs across the state, 102 counties, I think like 90 plus, have said that they won't enforce this law. So, I mean, that's a whole bunch of law enforcement agencies across the states that apparently don't feel semi-automatic weapons are a threat to law enforcement. So interesting to note on that. But while the state of Illinois and city of Chicago, Cook County, Naperville, while they defend their gun and magazine bans in the Seventh Circuit Court of Appeals, you have Oregon, an interesting thing taking place there with a trial opening up about Oregon's voter-approved gun control measure that's considered some of the most strict in the nation. And this is after voters in November narrowly passed Measure 114, which requires residents to undergo safety training and background checks to obtain a permit to buy a gun. It also bans the sale, transfer, or import of gun magazines with more than 10 rounds unless they're owned by law enforcement or a military member or were owned before the measure passed. So you have several organizations, and including an Oregon sheriff that filed a lawsuit against this. An attorney for the plaintiffs said in an opening statement Monday that the law violates the right to bear arms under the Second Amendment and the Due Process Clause under the 14th Amendment of the U.S. Constitution. Quote, this case is about constitutional rights, the right to keep and bear arms, as well as the rights to be free from the taking of property. Now, the defense in Oregon, they say that large capacity magazines should not be considered bearable arms and represent a dramatic technological change. Where have we seen that before? Oh, yeah, the Chicago filing. So they say that that's why they have to be able to regulate these firearms. Just stepping back out of Illinois and looking at all the other cases that there are concerning challenges against gun regulation across the country, there's a lot of moving pieces. Some things could drop in a ruling that could impact Illinois. Illinois could be the benchmark moving forward, depending on how fast this ruling comes out of the Seventh Circuit and whether there's an appeal. And you also have just these timelines all in flux and a lot of fluidity when it comes to when these things are actually going to be decided, and are we going to see these things decided before the January 1st deadline here in Illinois for people to register their firearms. Still a lot of moving pieces, not much certainty, but we do have at least the ball rolling in the Seventh Circuit Court of Appeals with the filings that have been put out there by at least Chicago. And again, you've got the filings from the state of Illinois that access to their filings are limited to counsel of record. Once the document's approved by the court, it'll be filed on the court's docket as a separate entry that we can then view as the public. So that's straight from the docket, the Seventh Circuit Court of Appeals, and we'll be watching that space closely.